Hello, and welcome to the first of these lectures on equity and trusts. It's unusual in two senses. Obviously, firstly, in that this is not a this is a presentation that's been given using audio visual technology rather than a live presentation in a lecture room. But it's also unusual in the sense that we are revising or revisiting a matter that's really part of the core understanding of the English legal system, at least from the point of view of legal history, namely the origins of the common law. How did the common law come to be? Why do we need to go back in time to look at this? Fundamentally, we can't understand equity unless we understand the relationship, the interaction between law and equity. And note, I'm using the term law here to mean the common law, that specific sense of the case law body of rules developed by the common law courts. Come on to that in a moment. We will often talk about we have this rule at law and that rule in equity, and that is fundamental. It may be something we can criticize. Indeed, Andrew Burrows does in an article very much in those terms. We do this at law and that in equity. From the point of view of a modern legal system, it's very odd, as it were, to talk about two beating hearts, a beating heart of common law and a beating heart of equity. Most people get by rather more simply in a body that only has one beating heart. It's only if things go wrong that you need a pacemaker. So, and that to some extent is what has happened in the common law. We have a rather old, decayed heart, and we have added a pacemaker, which has been equity traditionally. In practical terms today, you might say it's statute law, in order to remedy problems in the system. Those problems, as I'm about to show, are to some extent baked into the early development of the common law. In other words, understanding how the common law developed helps us understand why the inverted commas natural solution was the development of the courts of equity. Okay, so without further ado, I am going to disappear and we'll move on to the next slide. Now, the roots of the common law are to be found in the desire of the Normans to cement their revolutionary takeover of England. It's important to appreciate that before the Normans invaded in 1066, the country that they were taking over, England, was to some extent or had become quite recently a unified country. The Saxons had a relatively loose alliance of regional power bases, which had come together in a slightly egalitarian basis, but with perhaps a hegemony based in Wessex, but certainly had been a more egalitarian society than the Norman feudal society that was about to supplant it. That's important in two regards. It's important in terms of political governance. So the more, as it were, cooperative Saxon system, I mean, it's all relative, but to some extent the more cooperative Saxon system is about to be replaced by a more authoritarian system, a top-down, hierarchically governed society, rather than one with, as it were, a sort of balancing of power amongst the regions. And in terms of substantive legal aspects, we're going from a more egalitarian Saxon law, that the Germanic law was in some regards more egalitarian, at least as between men across classes. Obviously, women always had a rough time in whatever society until more recent years. But the Norman system was very much one based on the devolution of resources on a political basis from the top down. And was a system that favoured primogeniture, and one which therefore were, by modern standards, less liberal, less economically free, not a market-based economy, but rather a command economy, and to some extent with, as it were, political power resulting in local exploitation of resources by local chiefs who would, as it were, be able to exercise authority over their serfs. Pretty much, almost you might say, slave labor conditions. A very, very different society from the one that we take for granted today. So in 1066 we are moving away from more egalitarian law towards a very different set of legal premises and a much more as a top-down hierarchical society. And part of that obviously was the centralization of power in a political and administrative sense, which William was very keen to achieve. And it's his successors who particularly further the process of judicial nationalization or unification of the country, which was not a feature of the Saxon system. I say the Saxon system was a much more loose alignment. Politically, we have, as it were, the recognition of England, but we don't necessarily have a judicial England. Well, the judicial England is a product of the Norman era, which is why legal history before 1066 is, for practical purposes, irrelevant to us. It is this, for this conquest by William, defeat of the Anglo-Saxon King Harold at the Battle of Hastings, that launches the birth of the common law, ultimately because it's William's position as King of England importing this feudal idea of a top-down society with centralized power, which gives birth to the royal courts, which in turn gives birth to the common law. So what were those royal courts? Well, before we come to them, I will see that there are three main courts: the Court of King's Bench, Court of Common Pleas, and the Court of Exchequer. Before we come to those, we should understand a little about how they came to being, because it's not a natural process to split off the judicial from the executive. This is a product of the separation of powers, is a product of we would say now more modern thinking. We all know Montesquieu, but it emerged curiously relatively early in the medieval era, in the sense that it took only a few centuries to become cemented in practice, more out of necessity perhaps than anything else, because a busy king has got to focus on the busy matters of state, and dealing with disputes between nobles or the gentry is really just something the king cannot cope with. The king is keen to take control of administrative matters, and to some extent therefore also administrative law. I want to see that I have powers of supervision over local power bases, but I don't necessarily want to deal with the humdrum of law. And so it's no surprise that disputes that originally settled by the King's Council, i.e. with the king present on the basis of his advice, become matters that he eventually delegates to others. So civil disputes are plucked out from the King's Council. Members of the council, his council, are assigned to hear those pleas. This proceeds in the time of Henry II, who's very much a driving force then of a professional judicialization of these processes. The process goes on apace, such that by the 13th century, certainly a century later, we have cases which are not heard before the monarch, quorum regis, but rather there are separate benches hearing these cases, the King's Bench or the Common Bench or Court of Common Pleas, hearing these cases independent of the King, and indeed with their own Chief Justices. The designation of Chief Justice, might say, is not a particularly important matter because, well, it's inevitable. If you've got a body of people, you'll need somebody to, as it were, take the chairing role. But it is also important in terms of egos, because the Chief Justice was then a position of status within the state. And as soon as you have positions of status, that attracts people who have a strong ego, who wish to have that status. Well, we know that, of course, in the political field. It's no less true, of course, of the judicial field. People want to be the top dog. This slightly less collegiate framework in these courts, of course, is bound to encourage a sense of power, and with that, of course, the potential for power rivalries, both within the common law and, as we'll later see, between the common law and equity. We shouldn't ignore the personal in all of this. People with egos can be quite sensitive, and we'll see later Chief Justice Coke was a very powerful man, a very powerful judge, and was obviously very keen to protect what he saw as his power base, and that's based on the jurisdiction of his court. So this is something we'll have to return to. It's not particularly relevant for the story today, but it's an important point to return to, that the designation of a Chief Justice brought with it a certain increased status, and that itself sows the seeds potentially of questions of rivalry. So the courts develop as an offshoot from the King's Council. Obviously, Parliament develops also as an offshoot from the King's Council in another direction. So over time, we have both the development of legislative as well as a separate judicial power, separated off from the executive around the King, the Crown. But the process goes a further stage in that it ceases to be a court that moves around with the King to becoming a court with a fixed location. Eventually they settle on Westminster Hall. This became necessary because Magna Carta provided for lawsuits in the Common Pleas to be heard in a fixed place, that should not follow the Royal Court. You can imagine, of course, that a moving court is not a very practical enterprise. Either you're going to send people off to some distant castle for a case to be heard there, or in the medieval era, this is obviously more practical, you simply wait until the court returns to your particular town, be it Oxford or London or wherever it may be. So there was a very good reason why the barons, who are eager to obviously to have some degree of influence on the development of the law, why they should want to have a court more conveniently accessible in terms of its administration and operation. And that marks, as it were, a very key stage in the development of a distinct judicial power base within England and Wales. That originally only applied to the Court of Common Pleas and the Exchequer, also in Westminster Hall, but the King's Bench also joins them later into the 14th century. There were some cases, of course, where King's Bench judges would themselves be riding out into other areas of the country with the King, but that more or less stopped in the 15th century. So certainly by that stage we have really very professional courts, we might say, close to recognisable to what we have today in terms of their own rolls records. So they're responsible for their own records, and they're not merely part of the general administration. The judicial infrastructure is there. There is a professional judiciary which is dedicated to these matters. There is a complete separation off from the executive power base of the Crown. So those royal courts, as I said, the Court of Common Pleas, also known as the Court of Common Bench, different designation, but it is one court. The Court of Exchequer, which, as we'll see, was concerned with financial matters principally. It did have some equity jurisdiction later, but is principally a court of for fiscal tax matters. And the Court of King's Bench, or obviously later when there's a queen, such as Queen Elizabeth I, the Court of Queen's Bench. Those are the three royal courts that we talk about when we're talking about the historic royal courts. All of these swept away with the creation of the High Court and what was then the Supreme Court of Judicature, now the senior courts of England and Wales, in the second half of the 19th century. But up until then, ignoring some new statutory creations like the Court of Probate in the mid 19th century, what we are looking at is pretty much a static system, i.e. the royal courts created in the medieval era have survived through into the 19th century. That alone should send off some alarm bells ringing. The fact that your procedure has not developed, or your judicature has not changed markedly, even though society has moved through the medieval period, is a sign perhaps that certain reforms were necessary and must have been dealt with differently. We should remember what's going on through a large number. I mean, this is a wide span of time as we go through from the 13th, 14th century through to what is closer to the modern era, the 18th century, the 19th century. During the medieval period, the world does not remain static. We are moving towards a market economy. Obviously, the kind of scientific curiosity that we understand drove the Renaissance period, and likewise the kind of artistic creativity of the Renaissance has nonetheless some roots during the medieval period. We obviously have the turbulence of the Reformation and so forth. But beyond all this, there is a general process towards a more literary society. That's certainly true into the 17th century, for example, the Elizabethan period. We have more grammar schools. We start to have a society that's more able to write. And we also have a society that is much more driven around written records and documents. Certainly from the 1500s onwards, we start to move towards a more documentary society at further echelons of society, not merely the administration at the top. But we're moving towards the area of bonds, negotiable instruments, and so on into the 17th century. So we're starting to develop in a more economically liberal direction. The feudal system has long been in decay. At the outset of the feudal era, you're looking at this top-down society where the local chiefs had the land held from the king and pretty much were able to govern their serfs, their villains, as we would call them in English common law, basically on the basis that you get a strip of field and you're going to farm partly for me, yes, partly for yourself, but so many days' labor is my labor because you're basically in my domain. Well, that early feudal model is not going to survive the test of time, partly because plague means you lose bodies, and if you lose bodies, you lose agricultural labor, and if you lose agricultural labor, you've got to make up for it somehow, and part of that is to pay a wage. And so throughout this era, progressively, we're moving towards a more market economy-based society, and less one that is a command economy. And as the market opens up, and as technology improves, you start to have all the various commercial transactions that go with it. And there's a reason why I'm stressing the commercial aspect, because of course this is most crucial to equity. If we find the common law is unable to deal well with property transactions and aspects of contract transactions and other commercial aspects, companies, for example, or as we'll see later, trusts, then it's no surprise that we're going to try and find some remedies elsewhere which bring the law into line with the economic realities of what is going on the ground. As it were, the problems are not going away, we need to solve them more effectively. Okay, so it's important that we bear in mind that the fact that these royal courts remain the same as the national courts dealing with tax, administrative law and civil disputes. The fact that that structure has not changed, and yet society has gone through massive changes right through to civil war and fires in the 17th century and so on. That's a sign that a lot was going on that had to be dealt with by other mechanisms. Because unless these courts were radically reformed in their approach, they were not going to be equipped to deal with the problems that effectively equity did deal with. But we'll come back onto that in a moment. Let's go back then to these courts themselves. The aim of the royal courts was to as it were, draw jurisdiction into London. They are applying principles that they are also going to export out to the regions, and partly that's done by the Court of King's Bench. The Court of King's Bench is the top dog amongst these three courts. It is closer to the king. We've seen already that it's the last to be, as it were, firmly detached from the king, in terms of the king not being present, not taking part, and also it not being a court moving with the king. It's a court that has a judicial review jurisdiction, so an administrative law jurisdiction over local courts, local authorities, and also a review or appeal jurisdiction over the Court of Common Pleas. So even amongst these royal courts, it has an appellate jurisdiction, an appeal jurisdiction. We shouldn't necessarily assume that worked very well, and you can imagine a degree of rivalry amongst the courts, but that's something we can come on to another time. The Court of Exchequer obviously has a narrow jurisdiction. It's just about tax matters primarily. So effectively, the Court of King's Bench is the top dog. And it's through its wide jurisdiction that the Court of King's Bench is able to propagate national rules which will apply effectively across the jurisdiction. Local and manorial courts are kept in check within their more limited jurisdictions, and the more that the Court of King's Bench, as it were, can lay down common rules, the more the Court of Common Pleas can lay down rules which are to be applied everywhere by, as we'll see, circuit judges. Then effectively you are laying down a national law. And so gradually, with certain exceptions, customary law is displaced. Certainly true. Even into the 18th century, certain customary law rules still existed. They mostly affected things like succession to personal property law, things that the common law courts were not terribly interested in and effectively didn't always have a clear jurisdiction. Some aspects of succession laws, we'll see, were dealt with by other courts, by ecclesiastical courts, not by the royal courts. So in areas where the common law courts didn't have jurisdiction to intervene, some aspects of customary law could persevere. But in many large swathes of the law, basic commercial contract law, the law of tort, aspects of land law and administrative law, we have a complete displacement, more or less complete displacement of customary law by what becomes a national law. And that is the great contribution of these royal courts. They are nationalising the law. As we know, they're nationalising it on the basis of the system of precedent. They are accumulating a jurisprudence which is propagated by means of books in the later period, initially by judges' notebooks, by manuscripts passed down through the judges, but eventually those notebooks are published. There is legal reporting by attorneys and by barristers who attend court, not always accurate in their scribbling of the judgments. They're taking down as verbatim judgments, so orally given judgments, which they are recording as they happen. But the great success is that they are laying down national rules. As I say, in the 19th century, second half of the 1870s, this is swept away. The senior courts of England and Wales are created, then called the Supreme Court. But they have a great success in displacing the customary law. Okay, a little bit more on the particular jurisdictions of the courts. If we turn to the Exchequer, you may wonder about the term Chancellor of the Exchequer. Well, you can see now, of course, why the Finance Minister has this different designation than Minister of Finance. The Treasury Department, which the Chancellor of the Exchequer heads, is responsible for the executive side of tax raising and tax spending. That's split off from the judicial side. That was originally with the Court of Exchequer. Now, of course, tax disputes are dealt with by either the First Tier Tribunal or the Upper Tribunal on appeal, or by the High Court and onwards. But until the late 19th century, effectively, then these disputes would be dealt with by the Court of Exchequer. So the Exchequer split into the executive and judicial parts, just as the Court of King's Bench and the Court of Common Pleas split off from the King's Council. The term Exchequer itself, I should explain, derives from the checkered board on which the piles of coins would be moved. Literally in the early medieval period, where money is essentially precious metal, then those coins would be, as it were, stacked up on what would look like a chessboard with the different coloured squares. The different squares would denote different, as it were, accounts in the accounting system of government. So the money could be moved from one, as it were, one square to another in the process of divvying it out or spending it. And hence the term exchequer, from the, as it were, the checkered board or checkered cloth. That historical phrase, as I say, still lingers on in the designation Chancellor of the Exchequer. I indicated that the Exchequer was mostly concerned with fiscal matters, and that's certainly true, but something that happened with the Court of Exchequer also happened with the other main court, so the other courts, the Court of King's Bench in particular, and that is that the jurisdiction did expand over time. Not as significantly as for the Court of King's Bench, but it did expand on the basis of certain legal fictions, a big problem with the common law courts, the increased use of legal fictions, and that was partly in that by, as it were, a fictitious assertion of a tax debt in certain cases, or indebtedness to the Crown, could be used in certain circumstances to engineer jurisdiction for a private litigation between private litigants, not really involving the Crown, where the dispute might be about liability to pay. So the Exchequer could develop to some extent a private law jurisdiction, and did so later in its development. And so, as we'll see on the next slide, there were some overlapping jurisdictions in civil matters. Yeah. Looking at the titles, you would think that the Court of Common Pleas or the Court of Common Bench would be the natural court for civil disputes between individuals to be heard. So our contract law, commercial law, property law disputes, all of these should wind up with common pleas. And originally that was the Norman scheme. The Exchequer was confined to revenue cases. The Court of King's Bench would deal with some criminal matters. Most criminal matters would be dealt with at a local level, but it would deal with some pleas of the Crown in the classic sense of significant criminal matters. It dealt with administrative law matters, i.e. judicial review, at the time called error. So it would be keeping local authorities and local courts in check, and indeed any other bodies in check within their powers. And it would deal with disorder matters, irrespective of the whether it was technically criminal law or not, breach of the peace. That left civil matters to be dealt with by the Court of Common Pleas, but its jurisdiction was patchy. It had jurisdiction in trespass, in real actions, so in relation to land law, but not property law generally. It had jurisdiction in relation to debt, but not contract generally. And the whole concept of a contract was one that the medieval law struggled with in the early stages. A thing we have to bear in mind is that the notions, the abstract thinking that we have today is very much rooted in the abstract thinking that the Roman lawyers achieved. Our basic conceptions of private law pretty much derived from Gaius in Roman legal thinking. Forget Justinian, classic Roman law is enough. As it were, early Roman law had developed the basic abstract ideas. Well, the medieval mind did not, at least the medieval mind in English legal society, did not achieve that. The medieval mind was more procedural, less literate, less intellectually curious, less concerned, therefore, about what the monks and the scholars might be finding in the books. And indeed, it couldn't really draw on much of that scholarship anyway, because the great reception of Roman law within Europe that really formed the basis of or supported German codification and French codification, for example, and all the great reforms of the 19th century, particularly in 18th and 19th centuries in Europe. That knowledge simply was not yet extant. It simply, what we had at the time was relatively limited, poorly understood, poorly translated, and not freely available. This is not an era of cheap printing of books. Remember, of course, we've got to wait till the 16th century before books become, as it were, anything like more available than they were then. So there wasn't really a basis of abstract legal thinking on which one could draw, and so the channels that develop are the grooves that the feudal system, as it were, itself considered to be important. Possession of land was important. Abstract thinking about property law was not. Notions of possession were important, notions of ownership were not. So you can see straight away that if you don't think in abstract terms, you're likely to develop, if you think only in terms of shoe boxes, then, if you don't label every shoebox, if you run out of labels, then you're going to run out of you're going to create gaps. You're going to run out of pigeonholes for legal disputes. And that's more or less what happened here. There would definitely be things that were not within the jurisdiction of the Court of Common Pleas. To start your claim, you needed a writ from Chancery. Chancery was the secretarial department. You needed your writ, and if you could not get your writ, then you couldn't start the legal dispute. It was a procedural barrier to getting your claim into court. The Court of King's Bench had a different procedure by bill, petition. And later, much later, it developed a more expansive jurisdiction. Its notion of breach of the peace was expanded into a general jurisdiction over trespass, which in turn was expanded into a general civil jurisdiction. It moves from, as it were, through tort into contract law, breach of promise, as it were, as a wrong. That becomes the avenue, as I'm sure you'll know from those of you who've looked at tort law already. It opens up a wide jurisdiction for the Court of King's Bench, which, as it were, branches off into areas such as a contract and quasi-contract, as well as classical tort law. But this is a relatively late development. This is not an early development. So we have essentially three phases. We have the initial medieval period, where the courts are established. They are nationalizing, unifying the law, but they're unifying it based on rather primitive feudal thinking. We have the middle part of the medieval period, where these courts are, as it were, exercising their monopoly, refining the law, expanding it, and developing it on the basis of a system of precedent, so a consolidation of legal methods. And then we have the end phase, where the courts, as it were, in a more literate society, and particularly as we go into the 18th century, the 17th and 18th centuries, the courts are expanding their jurisdiction. They're becoming much more rivals amongst each other. Jurisdiction means business. Business means, as it were, profile, and to some extent also profits, because we've not got the modern civil service. We have, to some extent, payment by words. We have payment by commission within the administration of the courts and so on. There's a lot going on that is not still as professional as we have today. And above all, more court business is more status, and more status enhances your prospects into the future. So in the final phase, we have relatively wide jurisdictions, a much more abstract approach. We have the birth of contract law as we understand it today. We have a more holistic approach to legal problems, i.e. if there's a gap in the system, well, we can develop rules and develop jurisdiction to absorb those problems. But what we have to worry about is the middle period. The middle period is where we've not developed the expansive jurisdiction of the Court of King's Bench, but we have got the rigid methods of the common law. We have a system of precedent. We have rigidity potentially in the law, And those precedents cluster around medieval thinking. It's not clustered around the modern commercial liberal economic thinking that we take for granted, that really is born out of later developments, particularly the 17th and 18th century onwards. We think about the development of a company, for example. Well, company law is really a product of the 19th century as we would recognize it today. But the statutes of the 19th century were trying pretty much to build on existing practices that were born out of the coffeehouse stock exchange culture that developed in the 18th century. And the 18th century was itself building on partnership law developed in the 17th century. It's a continual process of development, but it marks, as it were, a period after the heyday of the medieval era. What is going on in the 15th and 16th centuries, and obviously even the 14th century? This is really the heyday, the high watermark of the medieval period. It is a system that is progressively being dismantled because of the various strains that I've mentioned earlier, in particular the economic upheaval caused by plagues and by the peasants' revolt and all these sort of things going on. It's a system that's progressively being dismantled, but the law needs to keep pace with that dismantling process, and there isn't the infrastructure to do it. So, as it were, if I can't think in abstract terms like a contract, how can I get justice in a dispute that is not technically a dispute of debt? It's not technically about possession of the land. And certainly if I can't get a claim to the ownership of land, a real action for possession of the freehold or ownership interest of land, but rather it's a claim involving a tenancy agreement, where do I go? Well, eventually I'll get some other remedies developed by the Court of King's Bench. But in the meantime, I might have to head off somewhere else. And as we'll see later, that becomes a question of equity. So, focusing on the middle period, the period before the Court of King's Bench expands, but after the consolidation of national power based in Westminster Hall, based in these courts, we have the problem of a rigid common law system that doesn't think in abstract terms, that's a bit like a Swiss cheese with lots of holes in the system of justice because it thinks procedurally, mechanistically, in boxes created in the early medieval period. And those gaps and defects need to be addressed. So, the great asset that the Normans provided, in particular Henry II, was the creation of a national infrastructure to unify the law, the creation of a common law, a term describing the law of these royal courts that applies across England, displacing local customary law. That's a great asset. It's a stable body of case law developed incrementally through the case law method, evolving through judicial decisions based on a system of precedent. That system of precedent becomes possible because of the reporting and publishing of decisions, not just judicial manuscripts, not just the reports produced, the nominate reports produced by barristers and attorneys who earned money by sitting in court and taking down these judgments verbatim, but also relatively early by the publication of the so-called yearbooks, which were also summarized judgments. Much of this is not very readable for us because, of course, it's in Norman French. The earliest reports are still in French, but the fact that those reports exist shows you that there is a striving towards a legal stability from a relatively early age. That shows a strong body of law. It shows a body of law that's going to be capable of ensuring its longevity into the future. But it has baked into it the defects that the system of precedent carries with it. If your precedents are based in a time of illiberal values, hierarchical society, a less egalitarian society, a less market open economy, then it's likely that those precedents are going to become out of date over the course of centuries. And the inability to deal with it is what gives birth to equity. These deficiencies in the substantive law, these gaps in the law, these rigidities in the case law have to be addressed. Now, the natural port of call today is to say this is a job for Parliament. If the judges are producing bad law, then Parliament is there to modify the law. But of course, Parliament in its current form as an interventionist legislator simply doesn't exist. Parliament is not necessarily concerned with the nitty-gritty of law reform. It's much more concerned with high matters of state, and it doesn't become a democratic institution, obviously, until into the 19th century. It's not really accountable to the people. It's not necessarily going to be concerned with the disputes that really affect the middle class. For a long time, it is simply the Parliament of a landed aristocracy, whether it's the Commons or the House of Lords, for that matter. So the natural outlet of turning to Parliament doesn't exist. What becomes the natural outlet is to turn to the King, and that gives us the key to the birth of equity we'll come on to. That deals with problems of substantive law. We shouldn't overlook problems of procedure as well, and questions of remedies as well. It's all very well saying, well, that's my land, I want it back, but do I have an effective remedy to get it back? This too was something that equity was concerned with. We'll come on to that in more depth later, but it's sufficient to say that the medieval mind was not just unable to develop abstract legal thinking, it was also unable to develop the machinery needed for more interventionist law. It's all very well giving a court judgment, but it needs to be applicable in some way. If you only have a limited number of limited resources to ensure that law is upheld, i.e., the sheriff needs to ride out on the horse with a few foot soldiers in order to ensure that law is upheld, you're going to focus your attentions on certain problems and not others. The practical application of law requires a culture of respect for it. That's not something that exists in the early days. And there's no point trying to develop a sophisticated machinery that has to be paid for by the state. So it's, again, a later phenomenon that the law starts to develop more imaginative remedies. If we think about remedies requiring a more kind of hands-on approach, such as taking of accounts, for example, these are things that equity develops later. They're not things that are inherent in the early common law. Likewise, if we think about aspects of procedure, subpoenaing witnesses and so on, these are the things that equity develops because it takes a much more hands-on approach to the trial procedure. It's a much more documentary-based procedure rather than the traditionally more orally focused common law procedure. There are all kinds of reasons why, as it were, there are gaps in the common law in procedural terms as well as in terms of substantive law. Before we leave this history of the common law, we should focus just a little bit, very briefly, on the Statute of Gloucester, which is the subject of the next slide. So the Statute of Gloucester was important in consolidating the development of the common law in a number of ways. Firstly, it restricted the jurisdiction of local courts. That jurisdiction was restricted to cases not involving more than about 40 shillings. Not a significant sum today. Today, 40 shillings is effectively £2, but obviously at the time would be much more important. But it was important in setting a ceiling. In other words, the most serious cases were predestined then to go to Westminster, to go to the Court of Common Pleas or the Court of King's Bench. Secondly, there was a presumption against a local jurisdiction. The quo warranto, or by what authority, principle applied. That was introduced by the statute to require proof of some title or some entitlement to hold a local court of law. So if you couldn't establish that title, be it by historic custom or by a royal grant, a franchise, then you would not be able to hold your court, and the relevant defendant in that case, obviously, would be able to appeal to the Court of King's Bench in order to have the local court order then quashed. So both of those principles obviously constrained the jurisdiction locally, and the system of heirs or itinerant royal justices made it possible for Westminster Justice, the national London Justice, to be made available in the regions. Judges being sent out on circuits. That was an early system in the Norman system following the Norman conquest. It was revived by the Statute of Gloucester as a way of making this common law practically available, with judges, as it were, going out on a circuit, delivering justice locally according to the Westminster law. All of this contributes to the very rapid displacement of customary law. And again, it underlines how the common law became a very effective machinery relatively early. Its weakness being it's developed nationally too early. It is not the sophisticated law that we understand in the abstract legal thinking that, as it were, later codifications could develop. It is, and we know over time, of course, that even the first codifications were not as sophisticated as those that came. If we compare, the French code with obviously the Prussian attempts, for example, we can see it's a much better job, or even for that matter, the Swedish codifications, and likewise, obviously, the German codification, much more abstract and much, I might say, better structured and better thought through than even the French code, the Code Napoleon. So we can see over each century that there's more legal experience to draw upon. In the 13th century, we are starting pretty much from scratch, save for these feudal ideas of how power should work. Those are the ones carried through. They are eventually adapted and continually developed, but within a relatively rigid structure, a structure that does not lend itself to, as it were, wholesale radical change. We are stuck within the system of precedent. We are stuck with a system built on early medieval thinking. And therefore, although we can make, as it were, evolutionary change within the strictures of the case law system, radical departures, different senses of justice that emerge as medieval traditions fall away and as we head towards the more enlightened market economy of the present, as that takes place, particularly into the 15th, 16th century, it's here that we really need a different approach, and that approach is provided by equity, as we shall see in the next set of lectures. So that wraps things up for this first set of slides. I hope that's given you sort of some sense of why we need to understand how the common law developed. Equity is parasitic on the common law. It's only because the common law had faults that equity developed in the first place. We might put it this way, that, as I say, that the common law is very much a beating heart, but it was a heart with problems, and it was problems, congenital problems almost from the start, because, as it were, the heart started pumping too soon, we might say. It's a flawed heart, and it needed a pacemaker, and the pacemaker came in the form of equity. So you wouldn't necessarily design a legal system to have a pacemaker from the start. You'd far better have a better heart to begin with. But it was the system that English law had. It had no effective parliament to reform the law, no interventionist parliament of the type we recognise today. It had courts wound up in a relatively rigid judicature, wound up in turn in a relatively rigid case law system. All of those, and a system that was not explorative in terms of more refined, sophisticated procedure or substantive law. All of this contributes to a need for change, and that change can only be provided by some other outside agency, given that it can't be provided by Parliament. all of this shows how that equity is developed as an historical accident, and this is a key thing that we will see. We wouldn't necessarily design things afresh this way. There are jurisdictions which are more closely tied to the historical roots than the English system now, which we'll also touch upon. But it shows that we can't escape the history. We have to understand that history in order to make sense of why we have, as it were, two beats. The natural beat and the artificial, the addition of equity, this kind of parasite on the body. It can only be explained in historic terms. We wouldn't necessarily design things that way, but it is important to remember that there are the two hearts, in the sense that we have both the body of law, i.e. common law rules, and the body of equity. It is the interaction of the two that, as it were, produces the justice, as it were, the artificial heart of equity acting as a corrective to the weaker, congenitally weaker common law heart. In practice, of course, the common law has since sort of tried to renew itself in various fields. We don't need to go into details of that. And to some extent, equity is now a decaying, rather old artificial heart. But it is a body that we still have that has the two. There is, as well, more interaction between the two. One might say there's some organic matter growing around the heart of equity, and statute, of course, as it were, dominates everything. But nonetheless, we can't escape the English legal system's continual reliance on an interaction of law and equity. If this interaction is to be displaced, it will be displaced by statute, as it were, in some sense merging the two rules or obliterating the two rules with a new statutory rule. That has happened in some areas, but so far as Parliament has not intervened, we are left with as well, the interaction of two bodies of case law. Okay, that's certainly enough for today. I shall wish you all best of health, and look forward to hopefully entertaining and educating you a little in the next set of slides, or when we look at the historical development then of equity.